Welcome to the podcast series Decoding Sustainable Finance, developed and presented by the Nova Center on Business, Human Rights and the Environment.
Welcome to another episode of our podcast series. I'm your host, Djabula, a research associate at the Nova Center on Business, Human Rights and the Environment. And today with my colleague, João Botelho, research assistant also at the center, we will focus on sustainability and strategic litigation. Strategic litigation means litigation used as a means to advance clarifications, protections, new interpretations, etc., related to certain rights. Nowadays, and due to the state of the climate emergency, strategic litigation has been used to protect the environment and to raise new issues and concerns. Strategic litigation is a powerful tool that can leverage the law to bring about social and environmental change. It involves carefully planned legal actions that could impact and challenge systemic injustice while advancing sustainable development. And we have seen examples of this all around Europe, and there are many more to come.
In this episode, we'll explore the transformative potential of strategic litigation with Professor Ivano Alogna. Ivano is a researcher leader in environmental and climate change law at BIICL and leads its rapid developing environmental and climate change law program. He is an associate member of the Sorbonne Research Institute in International European Law, Sorbonne Law School, a member of the European Law Institute project on ecocide, and is currently a Glasgow Law Fellow at the University of Glasgow School of Law. Ivano is a member of the World Commissions on Environmental Law of the International Union for Conservation of Nature and its Climate Change Expert Group, and an expert of Environmental Law and Policy Commission, the French Committee. He was also the General Rapporteur of the Global Pact for Environment Project, French Constitutional Council, and Club du Juriste. Furthermore, he's a licensed attorney at law at the Bar of Milan. He is also a university lecturer on global environmental law, climate change law, environmental liability, private law, sustainable consumer law, and comparative law. So, with any further developments in this case, we'll start our questions to you. First question, in your vision, what is strategic litigation?
Hi, Dussu. Hi, João. Thank you for the invitation. So we are talking about strategic litigation in the climate change law field. So let me start with some preliminary consideration about the context in which strategic climate litigation is taking place. When we are talking about climate change, we generally say that it is an always more evident super weak problem because the time is running out. There is no central authority to solve it, and those trying to solve it are also causing it. So states, unfortunately, as you know, are falling behind climate change despite the comprehensive international climate framework. So, you know, the UN Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement. And just last autumn, the UN Environmental Programme's Emission Gap Report found that the international community is falling well short of the Paris goal, with no viable pathways to 1.5 degrees. And they also stressed out that only a system-wide reform can escape climate disaster. So this, we can say, increasingly evident failure by national and international policy and law has forced other actors to act to combat climate change. And so here we have climate litigations with the lawsuits which are filed today by NGOs, by people, activists, shareholders, investors, cities, and also states against local and national governments. And these are the actors that are leading this fight against climate change in litigation. So climate litigation is, we can say today, a crucial component of the climate governance system at every level, globally, regionally, and also the local level. And it's quite important because in a way, climate litigation is really putting pressure on the executive and the legislative branches. I just had also that last year, for the first time, the IPCC, the Intergovernmental Panel on Climate Change, recognized that climate change litigation can affect the outcome and ambition of climate governance. So you've seen in the last years, domestic climate change legislation litigation have changed significantly our panorama, our world, the world in which we live, And we saw also how important have been global climate NGOs like Fridays for Future, Extinction Rebellion, that have highlighted government inaction. And also in a way, they have pushed lawyers to consider how to utilize the law to affect this kind of change that we want. And it is something that came like a trend, because over the last decade, many studies have tracked climate litigation growth. And in particular, for example, we have now different databases that are analyzing and they are taking stock of this litigation. So we have the Columbia University Sabin Center databases. There are two. There are the global one and the one that is just ready to US that show today nearly 200 instances worldwide. And these cases, in a way, demonstrate the lack of climate law in a precise way. And climate cases have been launched under laws controlling public and private actors and various climate change causes and effects. And as you probably seen, these cases include claims brought in tort, public trust, consumer law, corporate law, administrative, constitutional law, and also human rights law. So among all these cases that have considered to, we can say, to have flooded the courts, as I said, there are more than 2,000 around the world, especially domestic courts, several types of climate change litigation have been distinguished. So we have here the strategic litigation. So the strategic cases are those with a visionary approach. There are these kind of cases that aim to influence public and private climate accountability. On the other side, to understand also this category that we are discussing, we can compare this to what we call the routine cases. So these are less visible, I could say also less sexy sometimes cases, dealing with, for example, with planning application or allocation of emission allowances under the EU emission trading system. And so in a way, strategic litigation, that also been called impact litigation, aims to have far-reaching and systemic effect. The strategic climate cases are a small but always more growing subset of climate cases, as litigation is employed more for regulatory purpose. Direct or indirect pathways can achieve regulatory goals. So when a judgment explains or expands relevant legislation to encompass climate issues, this is direct effect. But litigation can indirectly also affect climate change goals through raising an awareness of an issue or climate injustice, or pressuring governments to modify legislation, or even influencing company culture to change behavior. So this is something that has been discussed pretty much all over the world, and the media and academia today tend to focus on what we call the pro-regulatory climate litigation, but not all the climate litigation seeks this kind of outcome. Many plaintiffs dispute legislation or policies that reduce greenhouse gas emission or other, we can say, positive climate consequences. And so these are what we call anti-regulatory cases that are usually filed by plaintiffs with an ideological or even financial stake in delaying climate action. And so not all climate cases fit this definition. Increasingly, we have also situations that might not oppose climate action and may delay climate policy solutions. Right-based climate cases may not oppose climate action itself, but rather its implementation or the effects on human rights. And these cases have been studied recently and can be called the just transition cases, which are, I think, a very new and fascinating kind of climate litigation.
Thank you so much for your answer, Ivano. You brought a lot of aspects to the forefront, and it is quite impressive how climate litigation is happening in Europe. And my next question, it relates to that, because when we look at other countries and we look at other continents, let's say North America, specifically the USA, you see that strategic litigation, divorce from climate, has been always happening. And most social advances, I might say, in the US, they have been connected to judicial cases and judicial reasonings. So from your perspective, How would you describe strategic litigation in Europe when compared to other jurisdictions, or even further, in your opinion, how is strategic litigation, climate litigation in Europe very specific or not specific at all?
Yeah, that's a very interesting question. About the US, we should say that, as I was saying before, we have a specific, we have some specific database on the US, just because the US is probably the most interesting, the most important in terms of number of cases, the most important legal system. Now we have practically 3/4 of the cases that have been filed in the US. But in Europe, the practice of strategic litigation is on the rise. And it's quite interesting because it's really developing quite rapidly. The first European climate change lawsuits were heard in the early 1990s. In the UK, where a few cases dealt with planning law and renewable energy initiatives. And today we have nearly 300 cases that have been reported since that time in Europe. So European climate litigation and policy is a phenomenon that boomed in the mid-2000s, we can say. The private parties were affected, of course, by European provision, by the 2005 EU emission trading system launch, as the EU ETS entered in its second phase in 2008. Litigation increased even more with a lot of other disputes surrounding the interpretation of the directive 2003/87, so the EU ETS directive, and also the relative competencies of the European Commission and the member states in the regulation of greenhouse gases. And then we can identify another moment is 2015, the Paris Agreement, the year of the Paris Agreement. Since 2015, courts across Europe have seen really a rising number and variety of climate cases. In this moment, climate cases have been documented in 20 European nations. So in the last 30 years, nearly half of European countries have already filed cases, strategic cases, climate litigation cases in general, and over 60 EU court cases and at least 10 cases before the European Court of Human Rights have been filed. So the UK, Germany, Spain, France also, they are those legal systems where we have more than half of the total number of cases. However, the legal trends that we are seeing now predict that most European jurisdictions will face climate claims in the next decades. So this is a trend that is really going forward. As with the rest of the world, most of these claims are against governments. I think it's over 70% of climate cases worldwide are against government, but also the case against corporations are rising. In Europe, there are 75% of the claims that have been launched against national and subnational governments, export credit agencies, and also central banks. Most of the scholarly literature on climate change litigation focuses on case against private parties, but they are just 16% of the European climate proceedings are against private parties. So this is a field that is quite interesting. However, litigation targeted and private actors in Europe is on the rise, and at least 40% of such cases has been filed since 2020. So this is really something that we are seeing in the last 2-3 years. And at BIICL, where I work at the British Institute of International Comparative Law, we are currently analyzing this new trend of litigation in this new project of ours on global perspectives on corporate climate legal tactics. The idea is to produce a global toolbox on corporate climate litigation. And just last week, we hosted an event on this topic. You can find, if you want, the recordings and event report on the BIICL website. And in a way, this is quite interesting because strategic litigation in Europe is made by different kind of actors, as I said, and has seen over 50% of the climate cases filed by individuals, civil societies, and these players bring most strategic climate change litigation, but the governments also at various levels bring 15%, And the corporate actors themselves are quite important because they also bring more than 30% of the total cases. So these kind of cases mostly entail disagreements, generally over how national or EU climate policies affected the parties involved. And of course, these kind of parties will certainly continue to sue, considering that climate change is becoming, as we are seeing, unfortunately, are always more important and increasingly pressing concern. And so national governments are introducing and implementing stricter climate legislation. So this phenomenon is not equally distributing among European countries, we should say, and this is due to major litigation cost differences. In numerous European countries, lawsuits costs may prevent climate lawsuits. So, as I said, climate cases are really varied, and they are quite interesting because they might include like kind of cases like a contract disagreement between like a Latvian hydropower plant developers and the government, or for example, a challenge to Bulgaria's EU ETS emissions allocation cancellations. They are really quite heterogeneous. So global climate litigation databases, as I said, such as the Sabin Center or the Grantham Institute at the London School of Economics, they show really a comparable variety of these kind of cases. Focusing on strategic lawsuits, we might also finish by highlighting that strategic litigants have three main motivations. First, to promote climate action, of course, by forcing government or corporations to reduce emissions or to implement climate policies and standards in specific decisions. These are what I called before the pro-regulatory cases, but could be also cases that are aiming to delay or to prevent climate action, what we call anti-regulatory cases. So last motivation, I could say, is the concern about climate change's unequal distributional impacts and the way in which the benefits and burdens of the transition are shared, the transition that we absolutely need. So this kind of unequal distribution impact can be understood as part of the category that I mentioned before of just transition cases. They do not seek to delay or prevent climate action, but in reality, they may do so in the short term. So we had now many scholars, multinational climate NGOs, as I said, and also lawyers, attorneys that are studying this kind of strategic cases. And the strategic climate change litigation in Europe, like elsewhere, has increased since, as I said, the adoption of the Paris Agreement in 2015. And of course, given the recent urgency of climate change discussion, this, I think, is quite inevitable and unsurprising.
Thank you so much for your answer. Now, looking to the sustainable finance aspect, what are your views of how strategic litigation will be in the cases related to financial instruments, to investing on just transition or not investing in the just transition, and in the investment and financing of sustainable development in general?
This is a very interesting question. I believe that climate litigation strategies and will always be more important for those cases that seek to achieve broader policy or legal change by challenging the flow of public money to projects that are not aligned with climate action, and also talking about private money. As you know, in addition to global goals on mitigation adaptation, the Article 2 of the Paris Agreement sets a third goal of aligning finance flows with the transition to a low carbon and resilient global economy. Finance, so, is a lever for action, and a lack of finance can hinder change. The Glasgow Climate Pact's text emphasizes finance as a tool for systemic transformation. A leading example is the case of Friends of the Earth versus UK Export Finance, which involved an administrative law challenge to the UK Export Credit Agency's decision to invest in this liquefied natural gas project in Mozambique. While this case was filed on administrative law grounds, it is qualitatively different to more traditional project-based administrative and permitting cases. that generally seek to oppose individual fossil fuel projects. This is what we generally use, and we find a little bit everywhere in the world on climate change litigation. And in a way, apprehending this evolution in case type is important for understanding the nature of contemporary climate litigation, where established areas such as administrative law are being used to bring strategic litigation in other ways by increasingly sophisticated claimants. Certainly, I think that a big push for new cases in the realm of finance will come from the EU. Certain transparency requirements under the disclosure regulation have already started to apply to the largest EU financial institutions. And this will be followed by the first phase of disclosure for financial and non-financial companies under the taxonomy regulation, much debated, with more detailed requirement flowing both from the disclosure and transparency regulations. Another important base, I think, for future climate litigation will certainly be the Corporate Sustainability Reporting Directive, which is expected to come into force from early 2024. And this introduces significantly more detailed ESG-related corporate risk reporting and disclosure requirements, and also expands the pool of companies which are subject to such enhanced rules. In particular, this directive will extend the scope of sustainability reporting to non-EU companies and group meeting certain EU size, and also turnover thresholds. Talking from London, in the UK, entities within scope are already required to make disclosure in accordance with the requirement of the Task Force on Climate-Related Financial Disclosures. And the first wave of this task force aligned disclosure for the largest UK listed company were required in early 2022. So these were for those companies with financial years ending in December 31st, 2022, with this obligation being extended to all UK listed corporations in 2023 for their accounting period starting from January 22 onwards. So the Financial Conduct Authority has already published a review of the first wave of this TCFD aligned disclosure, and also suggested various areas for improvement, which is quite interesting. Although the UK regime is slightly less onerous, both the EU and UK regimes require, we could say, granular reporting against ESG and climate-related metrics. And as you can imagine, false or misleading statements are an obvious source of risk. Regulators will be closely scrutinizing these disclosures, and there will be no doubt investigate and also take enforcement action against any non-compliance. But there is also, as you might imagine, a risk of direct civil litigation by shareholders, as we already seen in Europe, or investors who claim to have relied to their financial detriment on misleading statement to the market.
Thank you so much for your answer, and thank you so much for giving us that insightful comparison and analysis of all the aspects that we should take in consideration. So we have our final question, and it relates to the last point that you were mentioning. This question goes, how can different institutions, including financial institutions, decrease their exposure to litigation risk?
This is another interesting question. Of course, the litigation risk depends on the extent to which investments are really sustainable. As you know, the spotlight has already turned to the financial institution charged with funding climate impacting projects. A compelling example comes from Belgium, where the Belgian National Bank faced a challenge before the Brussels Court of First Instance that its purchase of bonds from greenhouse gas intensive companies violated its environmental, climate, and human rights related legal obligation. In this case, the Brussels Court rejected the claim that was in September last year and refused a petition to the European Court of Justice. DK Bank has already faced a claim that has now already been settled in Germany, alleging it misled customers about the positive impact of its DK Sustainability Impact Equity Fund. And NGOs have made no secret now about of course, their intention to target financial institutions. Recently, Roger Cox, one of the most successful attorney, at least in this corporate climate litigation field, you should remember of him for the Urgenda case or the Milio Defensi case versus Royal Dutch Shell in the Netherlands. He said that now that they have litigated against countries like in the Urgenda and have been successful, now that they have shown that one can successfully litigate also against fossil fuel corporations, that was the case of Milio Defensi, he thinks that the next step is to start also litigating against financial institutions who make these emission and fossil fuel projects possible. However, all those who have made net zero pledges are coming now under particular scrutiny, and also letter writing campaigns have been orchestrated, targeting the boards of major banks and pension funds. We can say that regulators are also closely scrutinizing perceived gaps between pledges and practice. HSBC, for example, has recently faced censure from the UK Advertising Standard Authority for advertisement that promoted its green initiatives while omitting information about its financing of companies with substantial greenhouse gas emission. And also the investigation of DWS by the US Security and Exchange Commission and the German Federal Financial Supervisory Authority said to have been prompted by claims by its former head of sustainability that the asset manager was misrepresenting how it used ESG metrics across its investment platform. And all of this kind of investigation remain ongoing. In France, a climate lawsuit was filed against BNP Paribas in the French courts. And this is quite interesting because it's a kind of new litigation that instigate wave of fresh litigation from civil actors against other banks and corporates that are deemed to have failed in the environmental responsibilities. So that was in February. NGOs Friends of the Earth France, Notre Affaire à tous, and Oxfam France filed a lawsuit in Paris, claiming that the bank had failed to comply with France's corporate duty of vigilance law, a law from 2017, because it had not required its oil and gas clients to stop developing new fossil fuel projects and begin to exit the sector. This French corporate duty of vigilance law, as you probably know, requires French domiciled companies to prevent and remedy harmful impact on the environment resulting from their activities and those of business in their value chain. And among the potential objections to the BNP Paribas case, there is the fact that fossil fuels industry are not yet forbidden by law. The claimants must prove that the general activity of this industry, and not a specific example, creates a serious violation to the environment. And also, BNP Paribas is a supplier to the fossil fuel sector, and the activity of financing is not explicitly targeted by law. And it has also been highlighted that the law targets the company that creates the violation, its main suppliers, and also subcontractors. This is also a very interesting model from the European Union perspective, considering the Corporate Sustainability Due Diligence Directive that is still being debated. In this case, the summons sent by Notre Affaire à tous and all the other claimants to BNP Paribas details multiple violations of the law, which are related not only to how BNP Paribas' plan is drafted, but also the lack of clarity concerning the report of information about investments and loans, and last but not least, the shortcomings of the measures that the bank allegedly implements to respect the parameters of the Paris Agreement. But just to conclude, this kind of litigation is not only a concern for banks. No industry today is immune. Any organization that seeks to differentiate itself from its competitors on the basis of its green credentials will probably also face a close scrutiny. And there are some bases for claim. For example, and it is one of the most interesting causes of action, greenwashing in alleged violation of consumer protection legislation that are underpinning by EU regulation and are therefore playing out in similar ways across Europe. Although we must say certain countries have adopted stricter prohibitions. For example, again, let's go back to France. Communication net zero commitments are prohibited now from January 1st, 2023, unless the company communicating on such commitments can make available to the public different things, greenhouse gas emission reports, integrating the direct and indirect emission of their products or services, the process by which the greenhouse gas emissions are avoided, reduced, or offset, and of course, finally, the method for offsetting residual greenhouse gas emission. So, at the regional level, to conclude, the European Union is developing new regulations, also in the framework of the Green Deal, that specifically address environmental claims to influence consumer choice. Until then, existing consumer protection regulations are being relied upon to tackle alleged instances of greenwashing, or as we call today, climate washing in advertising, and business that makes misleading claims to European consumers about the environmental credential of the product or their business practices face the prospect of regulatory action, direct claims for damages, and in some cases, even criminal penalties. So, concerning the second part of your question, if the risk of litigation can drive sustainable finance, I would reply yes. I hope so for them, for the financial institution, and I hope so for us all. So, thank you very much.
Thank you. Thank you so much for all your answers. They provided us with a great overview on climate litigation in Europe. And for our listeners, what are one of the two biggest takeaways from this episode?
I think that one of the most important things to retain is that in this moment, climate change litigation, strategic climate change litigation in particular, is really taking the lead in this new wave of creating a climate governance all over the world, and in particular in Europe, where as for our wishes with the Green Deal, we should be, in a way, the pioneer in this kind of field, in this kind of fight against climate change. So climate change litigation is going to be essential for the next stage of our fight against climate change. And I think also that nowadays we can certainly recognize that the role of the government is fundamental, but also we are going to explore always more deeply about what companies and financial institutions can do to help out in this green transition that we all need. So yeah, going toward this ideal or this geopolitical goal of sustainable development, we really need all the actors together to work in collaboration and trying to find a way of pushing even maybe the actors that are less likely to do so in a short term, to do so in as soon as possible and in the most effective way.
Thank you. Thank you for sharing your expertise with us, and thank you for being here today with the Nova Business Human Rights and the Environment Center.
Thank you very much. It was a pleasure.